Please rise. The Justices of the Appellate Division, Supreme Court, First Department. Hear ye, hear ye. All persons having business with the Appellate Division, draw near, give your attendance, and you shall be heard. Please be seated.
Interesting. Good afternoon, lawyers. Welcome to the Appellate Division First Department. It is wonderful to go back to our in-person traditional sessions. Although, as you can see, we're not quite back to normal. We've tried our best to preserve some of our traditions, which have not in the past included plexiglass and things of that sort. We are also wearing, as you can see, we're wearing masks, hopefully, as we can continue. We have to continue our traditions, but we have to keep things safe. So that's of utmost priority, both for the bar and for the court. It is, before I call the calendar, it is our tradition of this court to acknowledge new justices as at their first sitting. So today, the privilege of introducing Justice Higgins falls to me. This is something of a homecoming for Justice Higgins, as he served in this court as principal law clerk to our former colleague, Jim McGuire. He served from 2005 to 2009, if I'm not mistaken, John. Of course, since he left us, John has accomplished some wonderful things, including serving as a court attorney referee to the New York State Supreme Court in the Bronx County Civil Branch, as a contributor to the practice commentary of McKinney's Consolidated Laws of New York, and as a reporter for the New York State Committee on Pattern Jury Instructions on the civil side. He joined the bench in 2018 as a judge of the Court of Claims and has enjoyed what some would call a meteoric rise to the Supreme Court, Bronx County, then to the Appellate Term First Department, and of course now to the Appellate Division First Department. He is a graduate of the State University of New York, University College at Cortland, and Albany Law School of Union University. Welcome back, John. We are delighted that you've joined us once again, this time as a judge. And I will begin the call of the calendar. I've been a little stingy with the time. We have 18 out of the 23 cases being argued today, so it's going to be quite a marathon. People versus William Dixon. Appellant Dixon will get 5 minutes, and one in rebuttal. The people will get 5 minutes. Thomas versus Rubin. Appellant Rubin will get 5 minutes and one in rebuttal. Thomas will get 5 minutes. P. Paul is submitted. Munoz versus Rock Group, New York. Appellant Munoz is awarded 5 minutes and one in rebuttal. The respondent gets 5 minutes. Schwartz versus Port Imperial. Appellant Schwartz gets 5 minutes and one in rebuttal. Respondent gets 5 minutes. ALQ LLC versus Kane. Appellant Kane gets 5 minutes and one in rebuttal. ALQ respondent gets 5 minutes. People versus Andre Girard. Appellant Girard gets 4 minutes and one in rebuttal. The people get 4 minutes. People versus Mitchell is submitted. East Empire versus Borough Construction, as per joint letter to the court submitted on September 3rd. The matter is submitted. Frey versus Health Management. Appellant Frey gets 5 minutes and one in rebuttal. Health Management responding gets 5 minutes. Karam versus Karam. Appellant Karam gets 5 minutes and one in rebuttal. Responding gets 5 minutes. T. Minland. Appellant Minland gets 5 minutes and one in rebuttal. ACS gets 5 minutes. Safari Land versus HB8 agencies. Safari Land gets 6 minutes and one in rebuttal. Respondent HBA gets 6 minutes. People versus Joshua Paniagua. Appellant Paniagua receives 4 minutes and one in rebuttal. The people gets 4 minutes. Coombs versus Selekowitz. Appellant Selekowitz gets 4 minutes and one rebuttal. Respondent gets 4 minutes. People versus Garcia. Appellant Garcia gets 4 minutes and one in rebuttal. The people get 4 minutes. Gontarek versus New York City Transit Authority. Appellant Transit Authority gets 5 minutes and one in rebuttal. Gontarek gets 5 minutes. People versus Keller. Keller appellant gets 4 minutes and one in rebuttal. The people get 4 minutes. People versus McClinton. Appellant McClinton gets 4 minutes and one in rebuttal. The people get 4 minutes. Bank of America versus Philho is withdrawn as per stipulation of the parties. Rodriguez versus State of New York is submitted. Matias versus West 16th Street, 16th Realty is submitted. Commission versus New York State Division of Housing and Community Renewal is submitted. First case on the calendar is People versus Dixon.
Good afternoon, Your Honors. We had communicated that this case was being submitted, so good to go. Thank you.
Okay, thank you. People versus Dixon is submitted. Thomas versus Rubin.
May it please the court, Mei Chiang, counsel for Defendant Appellant Rubin. The lower court abused its discretion.
Counselor, before we reach those issues, does this court have jurisdiction to hear this appeal? It's my understanding, hold on, let me finish. My understanding that co-defendant died some time ago, correct?
That is correct, Your Honor.
Was there a substitution made in this case where the estate was brought in?
There is no substitution that has been made.
So then how do we have jurisdiction to hear the case until there's been a proper substitution?
I believe this court has jurisdiction because the order affects my client's rights going forward, and that
isn't under our case law, isn't the order void if it was issued without proper issued before there was substitution?
The order was issued earlier this year, and I believe Ms. Dudek had already passed away at that time.
Oh, isn't it void? Isn't that what the case law holds?
I'm not aware of that, Your Honor.
Okay, thank you.
The lower.
Let's assume there was jurisdiction. So tell me why was there an abuse of discretion to continue to allow the plaintiff here to proceed anonymously, at least through the first stages of the trial?
Yes, Your Honor. The lower court ran afoul of the strong presumption in favor of judicial openness and transparency, and this court's explicit guidance that anonymity should not be granted widely.
Well, so in this case, it's my understanding, or there's an allegation at least, that Mr. Rubin was engaging in tactics that may have called for an anonymous plaintiff.
Your Honor, there is a 10-factor test that the lower court must consider.
What about Mr. Rubin's own conduct? Is that something that we can consider?
It is one of the factors in that the factor calls.
And did Rubin threaten to out the plaintiff in a certain way?
The complaint does allege that, Your Honor, but what courts require is that the plaintiff herself should have submitted an affirmation or an expert declaration saying why proceeding in her own name would harm her. And the record below.
But the court can make the decision using those Zool jewelry factors, right?
The court may make that decision.
Which is what the court did here.
The court may make that decision, Your Honor, but it abused its discretion by granting the order because plaintiff had not submitted any kind of affirmation. And she even represented to the lower court that she would proceed under her own name regardless of whether she won the motion. That shows that she doesn't suffer any harm from proceeding in her own name because she conceded that she would continue with litigation.
But isn't there a middle ground here, which other courts have adopted in similar cases, that she be anonymous now, but at an appropriate time, that her identity be disclosed?
Courts have also recognized that even under that middle ground, a defendant still suffers prejudice at all stages of the litigation, and that comes directly from Doe versus Skyline Autos.
What would be the prejudice that this defendant would suffer if this plaintiff were to proceed under a pseudonym?
I'm sorry, Your Honor, could you repeat?
What is the prejudice that this defendant would suffer if the plaintiff were allowed to proceed under a pseudonym?
Courts have recognized that a named defendant proceeding against an anonymous plaintiff faces prejudice at all stages of litigation. The plaintiff gets significant settlement leverage while...
But the decision was not at all stages of litigation. We're talking about the preliminary stages, right? And if you look at the factors in Zool Jewelry, it talks about balancing the public interest in open proceedings versus the strong private interest of a sexual abuse plaintiff or party, right?
Yes, there's a 10-factor test, but here the lower court made an error because plaintiff's identity has already been disclosed to the public and in connection with the allegations in her complaint.
I just want to go back for a second with the prejudice to Reuben, because isn't he a named defendant in 2 other lawsuits, and he didn't seek to protect his identity in those lawsuits? Am I correct about that?
You're correct about that, Your Honor, but the reason that Reuben contested anonymity here, and I know that my time is up, but
I'll give you 30 seconds.
finish the answer to the question, is that plaintiff in this case has made allegations that Reuben caused her injuries, but she's also made public complaints and allegations to the police that someone else caused her injury. So there's specific prejudice and specific circumstances in this case where that justify the plaintiff proceeding in her own name.
Thank you.
Good afternoon, Your Honor. My name is Mandeep Minhas. I represent plaintiff respondent Rachel Thomas.
Counsel, can you address the issues that concern me in this case as to whether or not that we have jurisdiction to even entertain this appeal as Ms. Dudak is deceased?
Your Honor, I would agree with you that this court does not have jurisdiction over this appeal. I would also like to correct the record in that Reuben sought to destroy the ability of the plaintiffs to proceed under pseudonymous names into federal court action, which is currently set for trial in 2 months in November in the Eastern District of New York. The court only allowed the plaintiffs to proceed under their legal names when, in October 2019, when the trial, on the eve of the pretrial conference.
And now, what's the status of proceedings in this case?
In this case, Your Honor, the case is to pending discovery. And in the federal court action...
Sorry, counsel, have there been depositions? I mean, is it just paper discovery being exchanged? Where are we at?
Oh, we have not started discovery yet. There have been
We have not started discovery.
Have not started discovery yet.
Okay.
This matter is very much still in the pretrial stages, unlike the federal court action, which the court only allowed the plaintiffs to proceed under their legal names after the court determined that there may be possible prejudice because there are 6 plaintiffs in that action. And because of the 6 plaintiffs who all wanted to proceed under pseudonymous names, there was a concern of causing confusion amongst the witnesses and experts. However, this case is far from trial, Your Honor. I don't expect this case to be going to trial for at least...
You're not suggesting that you should be allowed to proceed anonymously through the entirety of the trial, correct?
Your Honor, with all due respect to the other courts, I am requesting that the court allow Ms. Thomas to proceed anonymously throughout the entire matter, including the trial. Here, it's a very different situation than the federal court action where there were 6 plaintiffs, and so the possibility of prejudice and confusion was actually greater. Here, we only have 1 plaintiff, and so the opportunity for prejudice is much lower. And I would also disagree with my colleague that there will be prejudice in the pretrial stages, because that's what discovery is for. If there are possible allegations that were made to a police report or to the media that are not addressed in the complaint, those will come out during discovery. So this court, I believe, should affirm the trial court's decision to allow
If we don't
Thomas.
have jurisdiction, then how can we affirm? Isn't it void?
Correct, Your Honor. It would be void if you do not have
I
jurisdiction.
mean, it would have been great if the trial court were notified when Ms. Dudak died, right? The motion was made, and the parties should have known that one of the defendants was dead and that at the state should have been substituted.
Correct, Your Honor.
So in as much as the court was not notified, he went ahead, issued the decision, proceeded with the trial, when in effect the trial was by operation of law stayed.
The trial is still proceeding against Reuben, however, Your Honor. And
Yeah, so you're not suggesting that there cannot be any prejudice. I mean, the underlying policy choice of freezing all proceedings until the estate is substituted is because there may be prejudice to that estate, and that estate should have a full and fair opportunity to litigate the underlying issues here.
Correct, Your Honor, but I think at this stage, we can at least decide whether there would be prejudice to Ruben himself, who is the appellant here.
But the other defendant is still a party in this case.
Correct, the other defendant.
And the fact that that other defendant is a party in the case, wouldn't that stay the entire proceeding?
Correct, but I still believe, however, that we can at least make a decision to the appellant, and then the estate can also.
Yeah, that's the part that I'm having difficulty with. If we have no jurisdiction, how can we issue anything?
I understand, Your Honor.
Okay. Thank you, counsel.
Thank you.
Your Honors, my only point in rebuttal is that you seem to be suggesting that there's a middle ground between allowing the plaintiff to proceed under a pseudonym in discovery, and then if the case proceeds to trial, she would have to proceed under her own name.
But that issue is really not before this court in terms of what happens after discovery, right? The only issue before the court, assuming we have jurisdiction and your adversary concedes in effect that the order is void, by the way, is whether or not the order as issued at this time in pre-discovery stages or through discovery, how should the plaintiff proceed?
I believe it was the plaintiff's burden to reserve on the estate and to notify the court that.
Oh, you're suggesting, well, it's not, okay. Thank you.
If Your
Thank
Honor
you.
has no further questions, thank you.
Thank you both. Munoz? Justice Higgins has recused in this case.
Good afternoon, Your Honors. Jillian Rosen for the Plaintiff Appellant. Our position is pretty narrow, that the Dr. Wordman's 3101D was lax in foundation. He provided no description of the methodology that he used to determine the force.
I mean, what was he obligated to provide, expert Wonderman? I mean, I agree with you. I mean, as a litigant, I can see why you want all of the information, certainly the theories, the peer review literature on which that expert is going to rely. As a judge, I think it's a good idea, so that way you have a full exploration of all of the issues and all of the theories coming forward. But some of our cases seem to limit how much disclosure there is. There's a threshold responsibility on the part of the expert, and it's only that. It's not a full disclosure, it's just a threshold amount of information.
Yes, Your Honor, I recognize the cases, even the recent case Velez by this court that said only reasonable detail, you don't have to just disclose the facts upon which the opinion is based. But in this case, especially with the biomechanical engineer, he should disclose the foundation.
Okay, so
for his,
I understand you say he should disclose the foundation. What case law supports that with under the guise of a 3101D filing?
Well, I have two cases for you. One is Shillingford against New York Transit Authority, and it's 147 AD 3rd 465. It was from 2017, and in this particular case, the defendants had failed to provide any data to support his position that, for example, the daily activity acceleration would be a proxy for injury. In this particular case, the expert was did not provide that, and you actually found that you had precluded the expert from testifying. Also, in Santos against Nicholas.
Wait, but was that raised on that case? What was the context? Was it based on a faulty 3101D response or something else?
It was plaintiff's motion to preclude the engineer from testifying based on his 3101D.
Okay, so you could have made that motion, couldn't you have?
We did make the motion. My client made a motion under 3126 and to preclude and to compel a further supplemental 3101D, and that's at, that is at, hang on. That's at page 7 of the record. But here, the very things, to answer your question as most directly as I can, he provides, Dr. Wordman provides a delta V of less than 10 miles an hour and provides an acceleration, gives a number of 2.6. But there's no explanation for how he arrived at the numbers, what the weight of the vehicles were, what the weight of the occupant was, what the forces were upon the plaintiff. He doesn't relate it factually to this case.
Why can't you ask those questions on cross?
Because the cross-examination, I recognize that that would be the question you'd ask me. The cross-examination, our position is, the cross-examination would be on the methodology. It wouldn't be on, so the cross-examination was, how did you arrive at less than 10 miles an hour? This methodology, is it accepted in the field of engineering?
So presumably your position is that the opinion testimony the expert's going to give is speculative, correct? It's not based on anything. It's
Hey,
speculative.
it lacks foundation. He hasn't.
Okay, so then don't you have a remedy, as some cases have suggested? You make a motion in limine.
Okay, yes, Your Honor, I recognize that. But what we're doing is we're trying, I mean, I know these are two cases out of the second department, but I think they're very worthy for you to look at. One is Doveberg, which is 154 AD 3rd 810. And the other one is Guerra, which cites Doveberg, and that's 185 AD 3rd 667. In those two cases, the plaintiff had made a motion, one was in limine, one was pretrial, to preclude based on very similar facts, where the biomechanical engineer just gave a conclusion without any foundation. And the trial court denied it, and they went to trial, and the expert was impermissibly testified. And then there was a defense verdict because the jury found that the expert was able to establish that these injuries could not have been caused by the force of the accident. And then the plaintiff made a motion, a post-trial motion, and the second department reversed. So I understand it's not this court, but if you look at the facts of those cases, it's very similar to what we have here, which is a complete lack of foundation.
I respectfully disagree, because really what we're dealing here is the sufficiency of the 3101D notice as argued by the respondent. And so when you're citing Doveberg and, two other cases, those are trial cases that relate to motions in limine. So we're dealing with the sufficiency. That's all we're dealing with. We're not dealing with a motion in limine at trial.
You're right, Your Honor. In Doveberg, it was a motion in limine, but in Guerra, it was a pretrial motion. And our position is, why should we wait till we get to that point? And the whole point is to prepare your cross-examination of the defense expert and also to prepare your client properly. And so our position is, if you look at my brief, it's all in my brief, but he doesn't provide any basis for his conclusions. They're just these numbers that come without any support.
Well, he said in his disclosure, his opinion based on his scientific material.
Yes.
That's the peer review stuff that he talked about.
Yes, the thing about the articles, can I do it on reply?
Yeah, go ahead.
Do it now? Okay.
Yeah, no. You can do it on rebuttal. You got a minute or two.
Thank you, Your Honor.
Good afternoon, Your Honors. May it please the court, Christine Fontaine for the defendant respondent. As Your Honor just stated, the only issue before the lower court was the sufficiency of the 3101D, not whether Dr. Wordman would be able to testify at trial. And one of the things that Justice Perez put in her decision was that the plaintiff's failure to refute any of the conclusions was one of the bases for the denial of the order to show cause, which sought, among other things.
But how can plaintiff refute something that he doesn't know anything about? I mean, the question is, the mystery is, what is the basis of the opinion of the expert that this accident could not have been caused?
Well, the basis was all the materials he relied on, which are in the 3101D, the photographs, the testimony, the damage estimates. Plaintiff has all the power in the world.
So in arguing sufficiency, you're saying what we submitted is sufficient?
Yes.
The photos, the theaters, the peer review literature.
For a 3101D, I think what plaintiff's counsels failed to do is distinguish between what's sufficient under the 3101D for disclosure and what may be sufficient for trial testimony. And clearly, it's respondent's position that the expert's disclosure was more and went well beyond the scope of what the 3101D requires. Also, as case laws hold, the trial court has very broad discretion in monitoring the discovery aspects of cases. Certainly, we get to trial. I mean, they can have a Fry hearing if necessary. They can voir dire the witness. They can certainly challenge any of his conclusions, as counsel's just discussed. But
How do you distinguish, if you can, the Second Department cases cited by plaintiff in her brief?
well, I think the Second Department cases, again, as I pointed out in my brief, almost all of their cases relate to trial testimony given, whereby the case went up on appeal after a verdict. And some of the courts ruled that the scope of the testimony was not permissible or admissible, and they reversed and sent it back down for a further trial. Again, it's a very, very narrow issue. It's the sufficiency of a discovery demand.
Well, the cases were reversed because the plaintiff, the expert was allowed to testify, in essence, outside the scope of the 3101.
Agreed.
Exactly. So here we are now. The plaintiff is making the argument that this 3101D is deficient, and you're saying that we should let it go to trial. Your expert will not be able then to testify outside the scope of the report, and then it's going to come back to us because the report was deficient and your expert should have been precluded, which is exactly what they want. Or what they want in other aspect of the motion that they want is to have you compelled to provide two things that they are seeking: the methodology and what are the engineering principles, the biomechanical engineering principles that your expert relied on.
Yes.
That way, if the case gets tried, your expert will be able to testify within the confines of the 3101, and we won't have to see you here again.
That would be the hope. I do believe the 3101D is beyond what the scope requires. I think plaintiff is essentially seeking an interrogatory and a deposition of this witness, which is not permitted under New York State law. And for those reasons,
Remind us, what's the purpose of a 3101D disclosure?
it's to provide your adversary with sufficient and reasonable detail as to what this expert is going to say, whether it's a biomechanical, whether it's a medical doctor, whether it's an economist. I think we've all been practicing law quite a long time to understand what the reasoning is behind providing it. Obviously, if it was just the name of a person and a CV, I would agree, it would be insufficient. I prepared the 3101D myself. I've worked with other attorneys in preparing them, more experienced attorneys, and I don't imagine that there was much more that I could have added to that disclosure. And the fact that the plaintiff, and Justice Perez pointed it out specifically, the fact that they didn't put anything into refute, there was nothing stopping them from retaining their own biomechanical, which I assume they will do.
But that's not the issue. I think, respectfully, that's not the issue. Is the sufficiency. On its face, the plaintiff doesn't have to do anything more. The 3101D disclosure is sufficient or it's not sufficient. That's the issue.
But it's our position that it is sufficient. Thank you very much.
Thank you, Counsel.
Your Honors, in your case of Velez against Roy, 191 AD 3rd 571, it's just a very recent case. They say that the purpose of a 3101D is to disclose in reasonable detail the evidence on which the expert will base his opinion. We have no evidence here. There's nothing. My adversary says, what else could I have put in? Well, we don't know if Wordman, he doesn't account for the position of the plaintiff. Did he look at the damage estimates? He doesn't have any amount of the vehicle's mass, the condition of the roadway. He doesn't mention the height or weight of the plaintiff. He doesn't show how he got to this number.
Counselor, we've all tried these cases, and that's fodder for cross-examination. It's done every day in the New York State Supreme Court, correct?
Correct. I just, one last thing about the literature, which I think is really important, is that there's 15 pages of articles and treatises, and even though they give the author and the date, there's no content to it, and he doesn't identify one article to validate any method that he used to conclude that these forces couldn't have caused this injury.
Well, that sounds like a great question in cross, right?
Well, but isn't the question, I mean, I'm not asking you this, no, I'm not gonna do that. Our position is the question on cross is, what did you use to come to a delta V of 10 miles per hour? What did you do? What equation
But
did
it
you
seems
use?
to me that your position is that the expert's testimony is speculative, and as counselor has indicated, and as case law provides, you have more than adequate remedies before trial to rectify that issue.
Well,
Motion and limiting, right?
well, I could do that, but I have a motion now that was before the court that we found was erroneous based on the lack of foundation, based on, it was just void of any information other than a conclusory number. So we feel it should be taken care of now, and so we could narrow the issue and go to trial with an appropriate preparation of our expert.
Thank you.
Thank you so much.
both.
Thank you.
Schwartz? Just give us a second. Let's wait for Justice Higgins. Whenever you're ready, Counsel.
All right, thank you, Your Honor. Patrick Owen for the plaintiff appellant, and I hope to please this court based upon submission of the briefs. I'm not going to reiterate what is in there because I'm aware that that's already been looked at. A couple of points, though, that I'd like to make during this argument is that the various cases cited by the defendants, respondents, in none of those do you have such a repeated failure by a defendant to answer a complaint which was repeatedly served upon them. In fact,
So you think it was reasonable the first time, but then once they kept messing up and Massey, I don't know how to pronounce it, once nothing was done, even after they were in fact given notice of the pending of the proceeding, you say that that makes it unreasonable.
at that point, it is unreasonable. There's not, this case is right on point with a decision by this court in 2017, Gekaj versus Gionage Realty, 149 AD 3D 600, wherein this court reversed the order of the court below, which had vacated a default judgment and reinstated the default judgment, wherein the defendant in that case claimed that, well, when we received these papers, we provided them to our insurance broker, and then nothing was done. And in that case, there was not as many times provided as in here. So, you know, defendants in this case have blamed everyone but themselves. They've blamed the third-party administrator repeatedly. They blame counsel for not reaching out to a third-party administrator who, if you check in the record, it's void of her actually informing me who she actually represented during this.
I just want to go back to that case you just cited because it indicates that that defendant's assertion in that case that he believed the broker was forwarding the paperwork to the appropriate insurance carrier was unreasonable in light of his conceded receipt of the summons and complaint, the motions for default judgment, a letter from the court. So that's totally different than what we have here.
Well, in this case, they conceded that they received everything but the motion for default judgment, which was served upon them, and it's in the record of the affidavit of service. Everything has been served upon them. That's the only thing.
Served out there, which address was it served upon? Didn't the corporation move in 2009, I think?
The one did.
Romulus.
Romulus,
Yeah.
which, according to them, they moved. They did not notify the Secretary of State that they moved. They ended up moving in with their company, Port Imperial, the other defendant, at the same location, so they received the summons and complaints, the CPLR 3215 notice, we say the motion for default judgment, the order granting default judgment and setting up an inquest, which they failed to attend. Now, one of the points that they made or brought up in their brief, and also to the court below, was that they're prejudiced and that had the third-party administrator done what she did in the past, that she would have given it to the insurance company and they would have provided counsel and they would have moved faster and they would have moved to vacate the order granting default judgment. But if you look in the record, there's nothing, no mention that they ever notified an insurance company, and an insurance company is not going to come in and defend them 3 years after the claim and after they've been handling it themselves.
Okay. Thank you, Counsel.
Thank you.
May it please the court, counsel for appellant. My name is Gino Zanghetti. I represent the respondents in this case, Port Imperial Ferry Corp. And Romulus Development Corporation. Your Honors, as the court is aware, the default in this case resulted from a very unfortunate situation where a very long-trusted third-party claims administrator that had been used by defendants essentially as outside claims administrator for their cases, who had been trusted and relied upon without incident for a quarter of a decade, essentially dropped the ball without our clients knowing. The summons and complaints that were received in this case were immediately in September of 2018 turned over to the claims administrator.
What about the other motions? I mean, counsel says there's a motion for a default judgment, motion setting down an inquest, notice of an inquest. Were those received by the corporate defendants, and what did they do with those papers?
The corporate defendants received the summons and complaint, immediately turned that over. That was September 2018. They did not hear another word in this case until mid-November of 2019. The plaintiffs have asserted that they served a notice of motion of a default in August of 2019. When this all came to a head, which was in March 2020 when we were engaged, my clients looked in every nook and cranny of their offices for the notice of motion for the default. They did not receive it. We've explained in our affidavits that were submitted to the motion court what may have happened, may have been misdelivered, but I would say this. Every paper my clients got, they turned over to Walters Nixon. The summons and complaint, after the notice of motion is alleged to have been served, they did receive in mid-November a notice of default. Upon receiving that, they immediately turned it over to their insurance broker to look into it. The insurance broker went to Ms. Mazzei at Walters Nixon, came back and told them everything's under control, she's on top of it, everything's under control, not to worry. Keep in mind that at that point, they had no reason to distrust Ms. Mazzei whatsoever. There had never been a problem with her. They relied on their broker's advice, who relied on Ms. Mazzei. About the notice of motion, which my clients didn't receive, in preparing for this argument, because they tore everything apart looking, they have no reason to default in this case. They're a very public company. They have assets in New York. They have other litigations. They defend their cases. It's not like they think they could run away from a judgment. They have no reason not to turn everything over to Walters Nixon that they got in the door. One thing I did notice, and I can point to the record, that notice of motion was sent to an incomplete address. The address for New York Waterway, 4800 Avenue at Port Imperial Boulevard. The notice of motion, the affidavit of service, and this is at page 19 of the record and 184, was sent to 4800 Avenue at Port Imperial without the boulevard on it. Now, I have no idea if that's why they didn't receive that, but they didn't receive it. And that's all we can say on that. Everything else they received, they turned over and they acted promptly. The next thing they knew, after the notice of that a default had been entered, and they went to their brokers, and the broker came back and said everything's under control, was then when they received the award at inquest of a $7.35 million judgment based upon this unwitnessed slip and fall case. We submit that the motion court below, Your Honors, I see my time's up.
Well, you can finish your sentence.
The motion court below properly vacated a default judgment. The court found that there were meritorious defenses which have never been challenged and that there was a reasonable excuse for the default. And there is a very long line of cases in the First Department on almost identical circumstances in which someone turns papers over to a broker or an insurer, there's a default that's entered, and the reasonable excuse is found. I'll sit down, but the Gage case that counsel cited is different, extremely different. There were at least 6 different
We're familiar
notices.
with the case, counsel.
Thank you, Your Honor.
Thank you. You get 1 minute, counsel.
What they really haven't identified is whether this is an outside or an inside adjuster, whether she's still utilized by
she
them.
fell on the sword. She said, I was overwhelmed. I screwed up.
Right, she fell on the sword for them because she's still working for them.
What does that matter?
It's easy.
What does that matter whether she's working for them or not? The issue is whether there was neglect or an intentional default here, right?
I think there's a issue as to neglect and willful default based upon a pattern of receiving documents. These are not unsophisticated people that were receiving these documents.
But doesn't that cut against you? I mean, they have a significant presence in New York. They're not going anywhere. What's their interest in defaulting?
What's their interest in defaulting? They just...
Particularly when there are questions about whether the accident actually took place, the location of it, and whether they had any control over it.
Well,
But that's for another day.
under the case law, though, if you continuously go through a pattern of neglecting and not answering anything and not notifying the insurance company, then that's willful neglect.
I got you. Thank you both.
Okay, thank you.
ALQ. Yeah. Interesting. He told me these are the ones that with no appearance were noted. Okay. People versus Gerard. Right.
Good afternoon, Your Honors. Lorca Morello for Appellant Andre Girard. Mr. Girard was convicted of shoplifting items from a drugstore of a total value more than $1,000. Our argument today is that the identification and the items must be suppressed where the people failed to show the lawfulness of the seizure, and that the warrantless search...
You rely a great deal on People versus Gonzalez for your argument that the evidence should have been, the motion to suppress should have been granted.
Yes, that is the central case.
Isn't this case different than Gonzalez?
No, it's actually quite on point, because in Gonzalez, in the same way, the people presented only the detective who elicited the confession from the defendant who had already been seized. But the testifying officer did not know anything about the circumstances of the seizure. And so the Court of Appeals, distinguished this from a case where the seizing officer testifies and the seizing officer is challenged about whether he had probable cause.
I mean, Gonzalez, you had a challenge to the reliability of the hearsay statement that was made, right? Or that was in question in that case. Here, the defendant matched the description of the perpetrator that was given by the eyewitness, the store manager, Peters, and confirmed by the photo ID and the video that the officer was allowed to see.
None of that is admissible unless the seizure was lawful. It is not whether, if you remember, Mr. Girard was seized in the subway station by 2 transit officers who held him.
And what was next? And I'm sorry to interrupt you, but did the officer notice anything next to the area where your client was seized?
You're talking about the seizing officers?
I'm sorry?
Are you talking about the seizing officers?
No, I'm not talking about the seizing officer. I'm talking about the officer in this case who went to the store and was advised by the store manager of what happened, given the photo ID, and told about the bag of drugs.
All right, so you're
I
talking...
watched the video before he ran to the subway.
This is not about reliability of the testifying officer. This is about the seizing officers. It doesn't matter how reliable...
The seizing, the transit
Yes,
officer?
exactly.
The transit officers allegedly arrested him based on a turnstile
Exactly.
jumping.
And they
no?
did not testify. And so the people had to show, because this was expressly challenged, whether their seizure, and that's the only seizure in this case, whether that seizure was lawful. And when they didn't testify, and when the only officer who testified wasn't there, didn't know anything about the seizure, it doesn't matter how reliable or credible the testifying officer...
So once you challenge, you're arguing, once you challenge the reliability of the transit officer, then it becomes incumbent on the people to establish that the officer possessed the probable cause.
Counsel, can you tell me how was it challenged? How was the reliability of the officer, the seizing officer, challenged at the hearing? Because your client didn't testify and did not present any witnesses to challenge that specific reliability.
It's firmly established that to challenge the reliability of police conduct at a suppression hearing, the motions are sufficient. And here the motion, this is CPL 71060, where the motion alleges, expressly facts of an evidentiary nature. That casts the burden on the people to show the lawfulness of the police conduct. And that was the case here. That's cited in the brief, that they had to show that the seizing officers, the transit officers...
Just questioning the evidence is enough? I mean, you say challenging it, but to me, I understand challenge to be, you present some evidence to refute that reliability. You can't just say, I challenge it and that's it, and sit down and then expect the people to come up with.
And he certainly did. He said, I wasn't doing anything. The transit officers grabbed me and they searched my bag. And that is the only matter in issue.
Did he say that on the record at the hearing?
He doesn't have to testify, Your Honor.
Did he provide an affidavit to that effect?
Sorry?
Did he provide an affidavit to that effect?
I'm sorry, I can't understand.
Did he provide an affidavit to that effect?
Yes, that's an affidavit. I mean, he doesn't have to provide his own. The attorney affirmation in the suppression motion is what does it. That's what casts the burden on the people.
Don't you need reasonable, as my colleague was suggesting, it's reasonable sufficiency to that assertion that I was just seized without reason? I mean, don't you need something more?
No, the burden is on the people to show that the seizure was lawful. It never shifts to to the defendant.
Okay, let me hear from the people as to what they think their responsibility is.
Thank you.
So counsel, if you want to start there, right? They read People versus Gonzalez as basically allowing them to just say, you know, you did it wrong. And then basically the burden shifts to you.
Yes, Your Honor, we would disagree with that reading. Actually, the version of Gonzalez that's cited in defense counsel's main brief and the reply brief is a dissent from this court before that case went up to the Court of Appeals. But if the court reads the actual Court of Appeals decision at 885, the last paragraph specifically says, the hearing evidence presented substantial questions concerning the legality of the non-testifying detective's conduct. And that's what makes Gonzalez so distinguishable from this case. In that case, there were substantial questions. Substantial questions
more
about,
than just
correct.
refuting.
The defendant in that case actually presented a witness who directly refuted. It wasn't just that the people's witness provided hearsay testimony. No one disputes that that is admissible. Again, the question is only whether it is reliable under Aguilar-Spinelli. And so in Gonzalez, the defense presented a witness that directly refuted the hearsay testimony of the officer who testified. It didn't help that that officer also had happened to only be at the station house after the fact and had nothing to do with the arrest. But again, the court noted that there were substantial questions in the hearing evidence. And here, aside from his motion papers, defendant never directly refuted the hearsay testimony of the detective who noted that the officers had first-hand eyewitness accounts of defendant jumping the turnstile. And so for that reason, Gonzalez is readily distinguishable. And the bottom line is that hearsay testimony is always admissible. It just has to satisfy Aguilar-Spinelli. The testimony of officers is presumed to be reliable unless directly refuted, and defendant simply offered no evidence to suggest anything other than this was exactly what happened. And the circumstantial evidence also helps that. It was in a subway platform right by the turnstiles, and that was a perfectly reasonable explanation for why defendant was stopped at that time. And unless there are any other questions, we would just ask that you affirm and rest on our brief.
I think we're good. Thank you.
Judge, that is a total misreading of Gonzalez. It does not depend on the testimony, and there are many, many cases prior to and after Gonzalez that make clear that when the defendant's suppression motion alleges facts of an evidentiary nature, and that is CPL 71060 subset 1, that casts the burden on the people to show the lawfulness of the police
So in other words, a general conclusory statement that I was arrested for no reason is sufficient to switch the burden.
He did not make a general conclusory statement, and that's cited in full in my main brief. He said, I was doing nothing wrong. They grabbed me, they took my bag, and they searched it. That was not a general conclusory statement, and the people didn't argue that below, and the court didn't find that below. That was sufficient to cast the burden on the people. And I would just like to say one last thing about Gonzalez. This is based on the dissent in the appellate division, which is more fuller, which explains that it is not testimony that casts the burden on the people. The defendant at that point has no burden to present testimony. It's only, and the many cases that I cite in my main brief applying Gonzalez, it is only that the defendant has to challenge the lawfulness of the search, and that casts the burden on the people to prove it, and they did not do that by just bringing in an officer who knew nothing about the search, whose evidence was the fruit of that seizure. Sorry. So in conclusion, I didn't get to the warrantless search of the bag, but I will just say that that the indictment should be dismissed here because the seizure was never shown to be lawful, and the search of the bag was never shown to be either based on search incident or on plain view.
Thank you, counsel. Thank you both. Frey versus Health Management System.
Good afternoon, Your Honor. I'm Arthur Lehman for the appellant. May it please the court, I'd like to introduce an attorney, Alan Harris, a member of the State Bar of Texas, who has been admitted pro hoc vice by this court, and I request permission that he be permitted to argue on behalf of the appellant.
Permission is granted.
Thank you.
Texas is not the place where he wants to argue these days, so welcome to New York.
Thank you, Your Honors. Alan Harris at Harris Law Firm, representing the appellant, Christopher Fry. We appreciate the opportunity to be here today.
Counsel, why should your client get a second bite at the apple when there's already been a determination by HHC?
What was the, I'm sorry, may you repeat the last part of your
Why should you get a
question?
second bite at the apple based on what occurred in Texas during the HHC proceedings and the subsequent litigation?
Yes, the HHS proceeding had a number of shortcomings that were fatal and unfair to Mr. Fry's case. And if you look at the cases that talk about the factors that courts usually consider in giving collateral estoppel effect to an agency proceeding, in this case, virtually all those factors were not satisfied. They were all shortcomings for Mr. Fry.
Was there, for example, an investigation?
There was an investigation, yes, Your
Were
Honor.
witnesses...
Where most of the witnesses you provided were in fact interviewed, right?
Most of them actually were not, Your Honor. We had suggested 45 witnesses.
And they interviewed 15, correct?
That's correct, Your Honor.
So can't they decide what they want to, how much they want to do in terms of how many witnesses they want to interview?
HHS certainly asserted that right, but our contention is that in the court of law, Mr. Fry would have control over what witnesses to depose and interview. And there were two key witnesses, for example, that could have testified to his protected disclosures being made up to the time of his termination, and that was a key factor in the causation decision of HHS. But those witnesses were never called to testify.
Didn't he have an opportunity to tell them which particular witnesses he wanted them to interview? I mean, he gave 45. They went ahead and they interviewed 15. And they also interviewed Mr. Fry, correct?
Yes, Your Honor.
So the fact that two other witnesses maybe that your client wanted to produce, does that somehow invalidate the fact that they interviewed 15 of the 45 witnesses you suggested, and that they also interviewed your client?
Yes, Your Honor, they did interview my client as well as those 15 witnesses. But again, it's a question of who did they interview? There were key witnesses that they did not interview, that in a court of law, Mr. Fry...
But they're not, counsel, they're not required to interview everyone you suggest. I mean, the difference when you go to an administrative agency and you try the case yourself is you call whatever witnesses you want, but when it's an agency doing it, they got to make sure that you get a full and fair opportunity to challenge those issues. They don't have to interview every single witness. That's not the standard, right?
That is not the standard. There really were not a lot of guidelines for how the HHS procedure should operate, but that's exactly one of the shortcomings in that Mr. Fry didn't have he was at the mercy of the determination of the investigator who to witness or who to interview, what documents to produce. There were key documents that Mr. Fry identified that were crucial to his case that he could not obtain through this procedure because the investigator did not ask for them or did not obtain them. Whereas in discovery in a court of law, he would have been able to do that.
Who chose to bring this procedure under the ARRA?
It was Mr. Fry, Your Honor.
So he could have gone to court to begin with, but he chose to go the administrative route.
Actually, he could not have gone to court to begin with. The procedure that ARRA provides first provides for the administrative procedure and an investigation by the government agency that has jurisdiction over the federal funds at issue. And so it's an exhaustion of remedies situation where he was constrained to go through the HHS process first before he could resort to action in court.
And that's after a finding or a determination by the agency that there is probable cause?
Yes, Your Honor. The way the statute works is either the agency makes a determination in the claimant's favor and then assesses damages from that point, or if it's against the claimant, then he can go to the court.
Then you get a right to sue letter or the equivalent.
Well,
the agency would allow you to proceed in court.
Yes, well, and the agency would actually, if it found in your favor, it would actually make a damages determination itself.
Okay. Thank you, counsel.
Good afternoon, Your Honors, and may it please the Court. Lee Crane for Defendant Respondent Health Management Systems, Inc. Your Honors, Justice Knock got it exactly right. Plaintiff's claim was fully and fairly resolved by the United States Court of Appeals for the Fifth Circuit.
I mean, what's interesting is that it really wasn't an adversarial proceeding before HHS, right? So they didn't have an opportunity to cross-examine, to challenge some of the evidence that was submitted by the employer to show, purportedly to show the underlying reasons for the termination, right?
It's true there was no confrontational conference, as Mr. Fry argues in his brief. However, as we note, courts time and time again have held that that's not a prerequisite by any means to applying collateral estoppel.
But we do agree that that's where the good stuff comes out, right, when it's adversarial. We've all heard about the nature of cross-examination and what it yields, right?
Understood, Your Honor, but I also note that Mr. Fry got even more process than some litigants do in court. Particularly, he had the opportunity to comment on 2 draft reports. And in fact, if you look at the pages around R400 of the record, Mr. Fry and Mr. Harris submitted something like a 17-page letter in response, effectively objecting and commenting on different provisions of the report. So in that respect, although there was no live testimony, no live cross-examination, there was plenty of opportunity for Mr. Fry to fully test and fully ventilate his claim. And I'd refer this court to Allied Chemicals in 1988. The question is not whether the proceeding is exactly identical to a judicial proceeding. The question is whether the court can have confidence that Mr. Fry was heard, that the facts were fairly aired, were adequately tested. Here you can have that confidence in spades. As Your Honors recognized, the Department of HHS interviewed 15 witnesses, reviewed numerous documents. Mr. Fry had the opportunity to appeal pursuant to the ARRA to the United States Court of Appeals for the Fifth Circuit, and he did. And he raised many of the same arguments he raised here before that court, and that court rejected it. And I'd refer the court to page R473 of the record for many of the claims that Mr. Harris made today. Many of the claims he says, with respect to the HHS, didn't look at this document, didn't take that factor into account. The Fifth Circuit said the agency considered these factors, considered these facts, and declined to give them weight. And that's exactly what the agency is entitled to do. I'd refer the court to the Rubens decision that we cite in our brief. It says when the agency is entrusted to consider these factors, to balance, to give weight, that's exactly the type of circumstance for which collateral estoppel applies. And Your Honor, I'd also note other factors that weigh in favor of collateral estoppel here. Mr. Fry himself invoked the proceeding, as I believe Justice Singh mentioned before. Mr. Fry was represented by counsel in many of Mr. Fry's cases, including Kosakow, including McLean. We're dealing with pro se plaintiffs.
But what I heard counsel say is that under the procedures, I mean, you don't have a private right of action to start in Supreme Court as you do under certain laws, anti-discrimination laws in the city. In fact, under the whistleblower statute, you can start in New York, you can start in court rather than through avail yourself of the administrative process.
I believe that's true with respect to ARRA, but I also will note that Mr. Fry had whistleblowing opportunities available to him potentially under Texas law. We cite Texas Human Resources Code 36115 with respect to our statute of limitations argument. And he's also here in terms of the New York False Claims Act. There was nothing stopping him from coming to the New York Supreme Court initially and claiming he was retaliated against for claims, as he does in his complaint, that relate to New York State. So with respect to the ARRA, he chose that proceeding. He understood he is presumed to have understood, because he chose that proceeding with counsel, what that proceeding would entail, that he would get Fifth Circuit review out of it, that he petitioned all the way for rehearing en banc to the Court of Appeals. He had not only a full and fair opportunity to be heard, he had a robust opportunity to be heard. And Your Honor, even if collateral estoppel did not apply, there are 3 independent bases on which this court can affirm. Collateral estoppel is one, but the other 2 are timeliness with respect to Texas and New York law. So I'll turn, if I may, Your Honor, to the New York False Claim.
You got 30 seconds, so get there.
Very quickly, Your Honor, we'd ask the court to apply the United States Supreme Court's reasoning in Graham. Justice Thomas, a strict textualist judge, reading exactly the same provision, exactly the same 4 or 5 words as we are reading them in context with respect to sections 190 and 192 of the New York False Claims Act. And finally, if I may, with respect to the Texas law, Your Honor, he effectively concedes the facts that establish that his claim accrued in Texas, and under CPLR 202, the 3-year limitations provision in Texas law applies, and his claim is long since time-barred. We'd ask that the court affirm on those 3 grounds.
Thank you so much. Okay, counsel, I'll give you 2 minutes and 1 extra minute since you came from far.
Thank you, Your Honor. Much appreciated.
And I know you were reluctant to do that, you know, under the circumstances. So.
Yes, well, I'm happy to be here now. Thank you. Yes, and to address a couple of points, the counsel mentioned that my client had the opportunity to comment on 2 draft reports by HHS. What also needs to be known is that there was a 3rd draft report that he was not given the opportunity to comment on, but yet the defendant was given the opportunity to comment on. Yet another element of the unfairness of the procedure and the incompleteness of the HHS procedure for Mr. Fry.
The statute of limitations argument.
I'm sorry, may I?
How do you address the statute of limitations argument?
The statute of limitations argument, we think you should look at the plain language of the statute. The statute says that a civil claim under this article has a 10-year statute of limitations. This article is Article 13 of the New York State Finance Law, and it includes not only qui tam actions, but it also includes retaliation actions under the New York False Claims Act. And under the prevailing case law, the legislature is intended or is presumed to mean what it said. There are numerous other precise references throughout Article 13 to sections, subparagraphs, etc.
Where did the cause of action accrue here?
The cause of action, the events that took place regarding the cause of action took place in Texas. We admit that.
The cause of action accrued in Texas. You're dealing with the Texas resident, right?
It's a Texas resident. It did happen in Texas, but it's a matter of New York law.
Why wouldn't we apply the borrowing statute to say it's a 3-year statute of limitations, Texas 3-year statute of limitations?
Well, I know of no authority, Your Honor, that would have allowed us to bring in Texas a claim under a New York contract, a claim that arose under my client's concerns of violations of the New York contract and New York law. Texas would not have heard that. It's a matter of New York law. New York has an interest in this case.
So you have a Texas resident asserting a claim or a cause of action that accrue in Texas against a defendant headquartered in Texas, right?
Yes, Your Honor.
Okay. Although, and the contract was in New York, you say, because the contract was executed in New York, that's sufficient.
Well, and what the contract dealt with was the services of the defendant to the state of New York under the Medicaid program. And so a Texas court, as best I can know from researching it, would not assert jurisdiction over that. The Texas procedure is for violations of the Texas Medicaid Fraud Prevention Act. not for violations of the New York False Claims Act. And that New York contract would not be subject to the Texas Act.
Thank you, counsel, and thank you both.
Thank you, Your Honors.
Karam? Go ahead, counsel.
Good afternoon, Your Honors. My name is Bonnie Rabin from Rabin, Schuman, and Partners, and I represent the appellant Egli Karam, who we believe was very unjustifiably shut out of court based on, we believe, an abrogation of the court's responsibilities under the standard review on a motion to dismiss. In fact, we believe she should have prevailed on absolutely every one of them, because as this court knows well, when reviewing a motion, the court is supposed to accept the facts as true and give the plaintiff the benefit of every possible inference and determine only whether the facts alleged fit within any cognizable legal theory. And here-
Doesn't the court have to first determine whether it has jurisdiction or not?
Yes.
Over the parties?
Yes, yes, and the court
How does the court do that?
The court does it by making an inquiry into jurisdiction. And if the facts are as alleged, as we allege them, are true, there is no question there was personal jurisdiction. There was personal jurisdiction under the matrimonial provision of the CPLR and also under the long-arm statute. But in fact, and again, inexplicably, the court found the facts in favor of the respondent here, which made no sense. Made no sense for this woman who was living with her child in an apartment that the respondent claims is not his apartment, yet if you look at the agreement that they signed in December of 2015, he had the exclusive ability to transfer it to her, not only in the separation, the postnuptial agreement that the court, again, unilaterally, without a hearing, without any inquiry, ignoring this court's decision in Lebedev, looking at any extrinsic evidence, determined on her own, without any hearing, without any discovery, that separation agreement was invalid, and which would have been yet another.
Counselor, can you address the certificate of acknowledgement? Do you agree that that was a certificate of acknowledgement in that agreement? Was that sufficient?
I think it was. I think it was under Galetta. If the court recalls, the Court of Appeals said, does it look at the specific facts and is in conformity? In this case, our client.
Well, substantial compliance. I think you're arguing that substantial compliance is sufficient.
It's absolutely substantial
but then
compliance.
how do you account for the Galetta case, the Court of Appeals, where it seems not to support that position?
Which case?
Galetta.
I actually think the case does stand for that position. It just says, not looking just at the specific language, but does it meet all the criteria of solemnity and the critical language, which it actually does. If the court looked at this case, our client went to the law office of her husband's long-term attorney, who also acts as his agent, who also acts in his person, and manages most of the real estate that he has in New York. And in his law office, with his specific notary signed, there was no question about who they were. There was no question about who either of them were.
Is that stated in the acknowledgement?
It's in the acknowledgement, which again, Your Honor, is only one of the 3 or 4 bases for personal jurisdiction here. In that agreement, specifically, it says that on the 11th day of December 2015, in the city and state of New York, before me personally came Oswaldo Karam Macia, MACIA, who being duly sworn by me, did depose and say that he is the person described in and who executed the foregoing instrument.
Doesn't there need to be language about to me known and known to me as well?
Yes, and that's
was
why
that
in this
included here?
case, knowing that This was a document drawn by Mr. Karam's attorney, done in a room with the four of them, which is with information that the judge didn't know. And that's one of the easiest things to cure. A notary and the lawyer who represented the husband could state, either in a deposition or an affidavit, he was in the room.
Well, okay, so let's talk about the notary here. Let's assume that Galetta does allow you to cure. Anything in the record to support that the notary can attest to personally knowing the parties?
No, and that's one of the issues is we aren't in.
So if it's not in the record, how is the court supposed to allow you to cure?
It could have been in the record. That's the point. The court stopped the ability to look into the bona fides and what was happening.
It wasn't, but how could you cure retroactively? I'm not understanding the argument.
The only way to cure is retroactively. You couldn't cure before the case. You see that there's an issue with the document. You see that the four people in the room are the two parties, the husband represented, his long-term lawyer there, and his notary. That is easy to cure with affidavits.
Okay. Thank you, counsel.
Okay. Thank you.
Good afternoon. Michael Mossberg for the respondent, Oswaldo Karam. For the reasons set out in our brief, we ask that the court affirm the decision of the trial court with respect to dismissal of personal jurisdiction. The burden was on Ms. Karam to demonstrate.
There's no question here, Counselor, that the husband does have substantial contacts with New York, correct?
He has contacts with New York, yes, Your Honor.
Is that sufficient, his contacts through his business, sufficient for there to be jurisdiction in the Divorce Act?
No, Your Honor. What
Why
you
is
have
that?
to have is a substantial relationship or a nexus between the cause of action, which is divorce or breach of contract, and the business transaction. And what the court below found and what is evident is there is no nexus, there is no substantial relationship, nor was none shown in the record below.
Does that create a nexus somehow?
Does what, Your
The
Honor?
apartment.
No, this is an action about breach of contract in a marriage. It's not about real property. So it has nothing to do with it. The cause of action
But it's
doesn't
in the
arise from
husband's business, real property, and the property is connected. It's marital asset, let's just say.
No, well,
That
there's,
doesn't establish
so there's it does not. One, there's a Venezuelan prenuptial agreement that is a separation of estates regime, which means title controls, so it would not put the apartment in the bucket anyway, but under A1, business transacted, or CPLR 302A4, you have to show a nexus or a substantial relationship. There was none shown here. This is a breach of contract, has nothing to do with ownership of property. The per se ownership of property under the law is not sufficient to demonstrate a basis under the matrimonial jurisdictional statute 302. So,
was the marital agreement executed in New York? And isn't that sufficient to determine whether that's a transaction of business or not?
If the court were to find that the agreement were valid, it would constitute a sufficient
I
transaction.
mean, it's in Spanish, but I happen to have read it.
Well, there's the prenuptial agreement, Your Honor, and then there's the 2015 agreement. The 2015 agreement is in English. It's 2 pages. Their acknowledgement is deficient. There is no consideration.
Well,
And
let me stop you there.
Yes.
Your adversary argues she should be given the opportunity to cure the deficiency, at least with respect to the notary. Why shouldn't she be given that opportunity?
This case, Your Honor, is on all fours with Galetta. What Galetta said was where there is a core component missing, and the core component in Galetta was to me known and known to me, then you cannot cure. And the reliance on Weinstein is simply misplaced here. The distinction is in Weinstein, which was substantial compliance, what the Galetta court actually specifically said, the same is not true here where a core component of a valid acknowledgement was not referenced. In Weinstein, it was different verbiage. So you can have the substantial compliance where there's different verbiage. But what Galetta did was distinguish it for the very same words, to me known and known to me, which are the very same words that are absent here.
So why not permit a notary to say, well, I know the parties, they came before me on such and such date, and this is how I know them? Why wouldn't
The
that-
burden, because, Your Honor, the burden rests with appellant. An appellant could have, and the record is barren. The appellant could have submitted an affidavit attesting to the fact that then she was known to the notary, respondent was known to the notary. She could have put in an affidavit in the record below to state that the notary asked for identification or proof of who she was or proof of who the respondent was. But there is nothing in the record other than she signed an agreement. And therefore, you cannot come back now and seek to cure based on that.
Excuse me, at the very least, why shouldn't plaintiff get to seek jurisdictional discovery under 3211D?
Because the burden, Your Honor, no issues of fact have been raised in the record to warrant jurisdictional discovery. Under this department's decision in Cobb v. Ramirez, it is the burden of the appellant to demonstrate the possible existence of essential jurisdictional facts not yet known. In this case, you've got 29 exhibits, over 300 pages from the appellant. She didn't make it. She didn't do it. She's alleged transaction of business. She's alleged account ownership. She's alleged property ownership. They all fail as a matter of law. And here, as with the notary, as with respect to residency, Your Honor, she had firsthand knowledge as to where Mr. Karam resided. And for that, I point the court to the record at 225 and 228. She never says anywhere that he moved here, that he resided here, or that he lived here, which was a finding of the court below. Indeed, at most, she says, he traveled to New York many times at 225. He came to New York very often at 228. Mr. Karam explored the possibility of obtaining an L1 visa so that he could move to New York. He could not be residing in New York if, pursuant to her own affidavit, he was looking into ways to move to New York. And so, therefore, she has not made the sufficient start under the Sunlight decision, warranting a basis for her to move forward with any discovery whatsoever. It was within her purview, and she failed to meet her burden.
Thank you, counsel.
Thank you, Your Honor.
She did meet her burdens, Your Honor. She stated very specifically that she, with Mr. Karam's daughter and their daughter, a second child, enrolled in schools here. She also stated that they worked towards getting visas, and he was doing that as well. But if I may, counsel is ignoring the other personal jurisdiction provisions in 302B. It says very specifically, did the defendant abandon the plaintiff in the state? That in and of itself, and she alleged that.
Were they living in New York State before they separated?
She was residing continuously.
She was, but
and
was he living in New York State with her before they separated?
He was residing with her, with his child and their child in that apartment.
When was the last time that they lived in that apartment together?
He went back and stayed in that apartment after they separated. But he stayed there continuously in 2014 until he left. He didn't leave until then, until that incident happened at the Pierre Hotel. And otherwise, that was their plan, to be in New York to stay. He had business. He enrolled the children there. We were absolutely staying here. They were residing here, and he left. Nobody says he has to reside there for a particular amount of time. They were residing there as a couple.
Thank you, counsel. Thank you both. Matter of Manila. Okay. Safari Land.
Go ahead.
Good afternoon, Your Honors, and may it please the Court. Jeffrey Deichman for the Appellants of Fireland, LLC. At the heart of this case is a written contract, an 18-page consulting services agreement, each and every page of which bears the stamp of the respondent HBA agencies, and each and every page of which bears the signature of HBA's president and CEO. The contract is unambiguous. It provides that Safariland will pay $7,500 a month as a consulting fee to HBA for a maximum.
Are there emails which might lead one to suggest, to reach a different conclusion?
Are there emails which suggest what, Judge Singh?
Which might suggest that the arrangement was different?
No, the emails from the sales staff basically say they're going to try to get a 10% deal. Obviously, those emails suggest and indicate that there were superiors that they had to go to in order to write the contract.
Those were the emails prior to the CSA, correct?
Correct. That's the parole
Were
evidence.
there emails after the CSA was issued that suggest that the plaintiff was entitled to a 10% commission?
None that I'm aware of, Your Honor. It's
There were no
only
emails post-CSA?
no, none that I'm aware of. Only the prior emails back and forth. Parole evidence should not be considered.
And why do you believe they shouldn't be considered in this case, sir?
Well, it's parole evidence. The agreement is unambiguous. The agreement has a merger and integration clause which says.
You mean any agreement, any emails exchanged after August 31st of 2016?
Well, it was September that the contract was signed, September of 2015. The emails that they're relying upon, the emails that.
But when did that CSA expire?
It expired in 1 year, in June of 2016.
So August 31st, right?
That's correct, Your
Did
Honor.
were they doing anything for you?
What they
after
were
that?
doing is what they were required to do under the contract. They were required to get business and follow up on that business.
After the expiration of
At
the
any
CSA?
time, if it related to the business. If you look at the affidavit.
So any work done after August 31st is a freebie?
Not any work.
So
Only
what
if it
would,
was follow-up
under
work.
your scenario, work done after August 31st, what would the plaintiff be entitled to?
They were already paid for that. They were paid $90,000.
So
That was the
my colleague is
contract.
correct. They're doing it for free, essentially. Anything done, for example, in 2017, there were meetings in the States. That's all free because that's covered also by the CSA, correct?
There's a distinction. If you look at the affidavit, he explains that the follow-up work related to the December 2015 order, which wasn't going to be delivered for several years until 2019 and 2020. And that additional work, that limited work, related to the order that they got during the term of the contract. It wasn't a new order. It wasn't something else. It was something that they were obligated to use their best efforts to procure during the contract term.
Were there any emails or verbal conversations between your client and the defendant's principal regarding payment of any commission after August 31st, 2016?
None that I'm aware of. None that are in the record. The only emails were that we'll try to get a 10% commission. And that omits many material terms of any kind of a contract. What's the duration of the contract? When is the commission earned? What's the termination? What's the scope of services? Just saying 10% doesn't make a contract, and it's all barred by the merger and integration clause. Their only answer to the merger and integration
The merger integration clause in the CSA that had expired.
Well, it expired in June of 2016. They had already obtained.
Right,
the
so
orders in question.
any work after, any work that they did after August 31st of 16 to procure any contract with MOD, why should they, I know you said before that was included as part of the work in the CSA.
Right. Because the only work that they did, as their president explains in his affidavit, was follow-up work to the December 2015
But Counselor.
It's work.
But also, Counselor, this is a motion to dismiss. And so the issue is our plaintiff's claims utterly refuted by the CSA. Argument can be made with respect to work done during the period the CSA was in existence. Harder to make once the CSA expired. A date that your client paid to terminate the services?
Right, I go back to their affidavit. It was relating to the sales order that they obtained during the period of the CSA. The contract says, the CSA says, they're not only supposed to get business.
So they're working for free after expiration of the...
Well, they're working for $90,000. These sales orders could have been canceled, and Safari would have had to pay the $90,000, whether they got orders, whether they didn't get orders, rain or shine, do work or no work, and Safari took...
So they get paid for the services that procure the $900,000, but they don't get paid after the expiration of that CSA for work which inured to you a benefit of over $2 million.
No, the $2 million sales order was obtained during the term of the CSA in December of 2015, before it expired in 2016.
When were you paid on that, Counselor?
Pardon?
When was your client paid on the $2 million?
They still haven't been paid. Those sales went for years later, 2019, 2020, 2021.
Well, I'm sure that if you enter into, they will be more than willing to enter into an agreement to get 10% whenever you get paid.
But there is no agreement. Their agreement said not to exceed $90,000. What could be clearer? It said it in the agreement that they signed, and they're
With an
bound by what they
expiration
signed.
date, with an August 31 expiration date picked by you.
That's correct.
Okay, thank you, Counsel.
Thank you.
Good afternoon, Your Honors. May it please the Court. My name is Daniel Goldstein of Smith, Gambrell, and Russell, LLP, Counsel for Defendant, HBA Agencies. If I could begin with answering one of the questions that Your Honors had asked before. Are there emails which might suggest a different arrangement? The answer, well, there's two answers to that. The first answer is yes, there is.
Okay, so when are the emails dated before the CSA was entered or after?
The emails that my client has provided to me so far are from before, but I haven't seen the emails after, Your Honor, because there's been no discovery taken yet. We're still at the pleading stage.
Sir. So if they're from before, what's your position with respect to your adversary's argument that they're barred by parole evidence? There's a merger clause here which says that it supersedes all oral and written decisions.
Sure. Several arguments to that, Your Honor. First of all, the contract reformation claim, parole evidence is not barred to prove mistake and contract reformation. We've cited two cases, actually I left my brief over there, but we cited two cases on our contract reformation argument that parole evidence is not barred to prove mistake.
What are you trying to reform? I'm really unclear about that claim.
Pardon me?
What are you trying to reform? You're saying the CSA should have been 10%?
Yes, Your Honor. If you look at the agreement that was reached in June.
Let's go back to the law. To show that, you have to show mutual mistake, right? One way of doing it is to show mutual mistake?
Yes, Your Honor.
You're not arguing mutual mistake?
Yes, we are.
Oh, there was a mutual mistake here?
Yes, there was, because when the contract was drafted, the CSA, the purpose and intent of that agreement was to compensate HBA $90,000 for the $900,000 sale, but it was drafted in a way by Safariland to intentionally avoid the appearance of it being a commission. That's because if Safariland paid a commission under
And did you suggest that at any point before the CSA was executed? Oh, future sales to MOD are not included?
What was going on here is that my client was dealing with the sales agents, representatives, executives at Safariland who emailed them saying, we will have an agreement for you to pay you 10% for these transactions. That is in writing. That's what they said to them in writing, and also on multiple calls. This is what my client has said to me. Again, there's been no discovery taken before, during, after the CSA. Keep selling, you will still get your 10% commission. So my client signed the CSA as an accommodation to Safariland, so it wouldn't have this appearance of paying a commission. And now Safariland is using that agreement, which contains a merger clause, yes, against HBA. And there are arguments to make that that merger clause does not apply here because, first of all, this was not an arm's length contract for the reasons that I'm saying. My client was not even represented by counsel. My client's not a lawyer. I'm pretty sure Safariland knew that they weren't represented by counsel. Again, there's been no discovery taken, but there were no edits that were sent.
Are there, I'm sorry.
Go ahead.
Are there any emails that, even if they were before the expiration of the CSA, they reference work that will be done subsequent to the CSA's expiration.
I don't know, Your Honor. No, not having even started
No,
discovery yet, I don't know.
No, I understand. I understand the absence of discovery, but that's something that your client would know, right?
My client,
If your client was told, as he kept, one of the arguments that you make is they kept stringing him along, you know, keep working, don't worry, you're gonna get you 10%, don't worry.
yes.
Is there anything that your client knows was exchanged with anybody about payment subsequent to the expiration of that CSA?
Your Honor, I don't know the answer to that question. This is why we believe the court below made the correct decision, which is at this pleading stage to allow it to go into discovery. But I think the way I would answer that question is there is absolutely zero explanation for why my client would continue to work beyond the end of the CSA for absolutely no compensation whatsoever. It's not
We don't work for free in America.
We don't work for free,
Okay.
and you know, it's not just what's in writing, but it's the conduct of the parties. The conduct
But
of
your
these
adversary, and you can respond to that, your adversary says, well, the CSA controls, you were getting these monies during that period, it's covered by that sum.
The money that was paid, by the way, was already achieved. They already secured a $900,000 sale and were paid their $90,000, their 10% commission. So why would they keep working on a $2.3 million sale? And I also do not read the CSA to require my client to continue working for free after the end of the term. So that would secure all of my clients' non-contract claims, all of their equity claims, all of their...
What about their argument, counsel's argument that the $2.3 million contract with MOD had already been secured before the expiration of the CSA?
That it had been, the contract was reached, but it was a 4-year time period for that contract to be reached and then to follow whatever MOD required.
And therefore for payment to be made, right? Because I assume that the government of Israel is not in the business of paying without having received.
Absolutely. Payment was not made until 2019, and that's when this whole dispute started.
Right.
I just want to go back to the reformation counterclaim because you indicated that it was a mutual mistake, but I'm looking at it. I don't see any allegations regarding any mutual mistake. It's a unilateral mistake by your client and nothing about misrepresentation.
It is our contention that the parties' meeting of the minds was for this $900,000 sale to be paid at a level of 10%, and that was the $90,000 CSA. And if they had known that this $2.3 million transaction was in the works, I would say that that compensation amount would not be $90,000, it would be $320,000, and that's the mistake.
Because it would include the $2.3 million.
Exactly,
Okay.
had they known
Thank
about
you.
that.
Okay, counsel, you get a minute.
Just to follow up on the mutual mistake that Judge Kennedy asked about, how could it possibly be a mutual mistake when my client writes an email that says, quote, just to clarify, I never promised 10%. There's no mutual mistake. We never intended 10%. We intended what the contract says. And how could this not be an arm's length agreement?
Well, he kept getting assured that, don't worry, we'll get you 10% because some of the executives at the top did not want to pay the 10%.
Right. We'll try. We'll try. We'll push for it. And they didn't succeed. And the agreement...
But I don't hear you saying, well, you know, it should be less than 10%. It should be 7% on the $2.3 million.
No, all he's saying is...
What I hear you arguing is all that work that they did for the $2.3 million, they did it for free. And I mean...
No. First of all, you're assuming,
happens, but
with all due respect, you're assuming with the benefit of hindsight that we already got paid the $900,000. That was going to be over 12 months. That could have been canceled. So we were taking the risk of paying them $90,000. That could have been canceled. They could have never gotten to 2.3, and we would have gotten no benefit. We were willing to take that risk. That's what the contract says. That's what they agreed to. They're a sophisticated party. They're bound by what they signed.
Thank you, Counsel.
Judge, can I get
Thank you,
one?
Bo. Oh, I'm sorry, John. Yeah.
Sorry,
No,
I just
we're
had
not
one.
done.
I just had one question for you. Which provision or provisions of the contract define specifically the subject matter covered by this contract or the scope of this contract, the CSA?
I believe there's a whole section entitled Scope of Services. And
If you don't put it in at least 24 font, I'll probably miss it, so.
that's at page 33 of the record, Scope of Services.
Thank you.
Thank you. Thank you both. Before Paniagua, let's take a 30-second recess for the court to be able to stand up and alleviate his back.
Just have a seat. Just have a seat for a second.
How am I doing? Tell you what, it's gonna be an all-nighter tonight.
I'm not gonna be there. I have to go out of town. I told David.
I gotta
I'll
call
be there,
him tonight.
but I'll be there for October.
I'm gonna have to call him on the drive home because, yeah, I had to pull the cases. It's just one thing after another the last 2 weeks. Now with this week, my mother.
All right. Court is back in session. People versus Paniagua.
Good afternoon, Your Honor. It's David Clem for Appellant Joshua Paniagua.
Good afternoon, Mr. Klein.
We encounter a lot of misery and sadness in our jobs sometime, and even amongst all that, Joshua's case stands out. 23 years old, college educated, no criminal history, employed, but with a mental illness. He tried to kill himself. The facts are undisputed. He lit the bed that he was sleeping or lying on fire and refused to leave in an attempt to kill himself.
Mr. Clem, he served the incarceration time, right?
Yeah, he just got out in May.
In May? So he will go through, if we keep the 5-year PRS, that will go through
2026, 5 years from May when he got out.
So let me ask you this. You say your client suffers from mental illness. Why wouldn't a 5-year PRS be beneficial to him where he could be monitored, hopefully, for these conditions as opposed to the minimum?
If in fact that's what post-release supervision did, I wouldn't be here objecting to it, but we know that's not what happens on post-release supervision. It's not that he is getting counseling and getting the treatment. He is getting that. He's getting that separately from post-release supervision. Instead, what we know is that over a third of individuals on post-release supervision are reincarcerated within a couple years on technical violations. In fact, that's one of the biggest populations going to our state prisons are technical violators for post-release supervision. It's a very harsh regime that is not beneficial to Joshua. It's not helpful to him.
The minimum PRS was 2.5 years, right?
That's right. And he was told he'd get the minimum. That's what the court said when he took the plea, is this is the minimum sentence. And he thought he was getting the minimum sentence, and that should be imposed now. He's not asking for his plea back. He's accepted responsibility from the beginning.
Sir, as a follow-up to Justice Singh's question, what specifically, what are the specific features or contours of the PRS that your client is getting? What are the burdens, responsibilities, the supervision that this particular gentleman is getting now?
It's not disclosed in the record what it is, and he's just at the beginning of the period of post-release supervision. So in the first 6 months of post-release supervision, there's full control over where he lives, including a halfway house. There's restrictions, obviously, on who he could meet with the employment he could get, where he could live, when he has to be back in his house, and who he could socialize with. Any violations of those, and it's quite common to see technical violations, failure to report to the office when required, or a curfew violation, can result in his reincarceration.
Is there anyone in any manner, to any degree, supervising or checking in as a component of his PRS with respect to whether he's on appropriate medications or he is receiving appropriate counseling for the myriad mental health issues that he is dealing with?
I don't have specific information on that. I don't believe that they could control the medication that he's on and his compliance. That's between him and his medical providers. I do believe that a component of post-release supervision during that initial period can be some monitoring of whether he's going to counseling or going to other programming.
Counsel, what, if any, steps is your client taking now to address his mental health?
Again, unfortunately, the record doesn't disclose that, and he's only recently been released from custody, so we don't have that.
But he did well while in jail, right? He was productive. He graduated from high school.
He attended college,
gainfully employed.
Yeah, I mean, that's exactly where I was going to go. We have a 23-year history before this incident where he had a mental illness, but was a very productive member of society. This was a period of severe depression that led to this one incident that, frankly, probably shouldn't have been addressed explicitly in the criminal justice context. And unfortunately, our hands are tied as to what we could do now, but what we can do now is limit the amount of post-release supervision, give him the 2.5 years that he was promised when he took a plea to the minimum. Thank you,
Mr. Clem.
Good afternoon, Your Honors. Julia Gorski for the people. This court should not reduce defendant's sentence for 2 reasons. First and foremost, defendant's valid waiver of appeal bars his excessive sentence claim. The record reflects that defendant's waiver was knowing, voluntary, and intelligent.
He was promised minimum sentence, right? Wasn't the minimum PRS 2.5 years?
Your Honor, defendant's cite to that comment is taken a bit out of context in the brief. Immediately prior to that, defendant stated that he understood that he was receiving the minimum period of incarceration with the 5 years of PRS. And then subsequently, Judge Warren contrasted the maximum he could have received for the attempted second-degree arson charge, which was 15 years, to show him, hey, you're getting the minimum period of incarceration.
He had no criminal record, right?
Correct.
So other than, I mean, this is someone, I mean, it's not like at the time of that he tried to commit suicide that there was any history of incompatibility with being around others or putting anybody else in danger, other than that one instance, right?
That's correct, Your Honor. And the record strongly suggests that defendant's mental illness, lack of a criminal record, social circumstances were taken into account in his underlying sentence.
But it wasn't in the PRS, right? Because he didn't get the minimum.
Briefly, in the PRS, it talked about defendant's mental health, but it did talk about his educational and vocational history. His mental health was detailed at length in the CPL 730 psychiatric evaluation, which was accessible to the court prior to sentencing.
Okay, how did he do while incarcerated?
That is not part of the record, so I'm unsure. But assuming that the plea waiver was invalid, defendant's sentence was certainly fair and appropriate. The record demonstrated that it was a result of a fairly negotiated plea agreement that defendant benefited immensely from. On the top count,
Are they really challenging that? I mean, he served his time, right?
correct.
So the question, I mean, the only thing that we can do for him now is reduce the PRS to the minimum, which he says, I know you say it's out of context, but he says that's the only thing that we can do for him now. So why shouldn't we do it if we balance, in the interest of justice, if we balance the potential harm to the community or anybody else from reducing the PRS? You're still going to have him under your thumb for 2+ years, right? Because it's May. Don't ask me to do the arithmetic, but you'll have him for quite a time, right? So if he stays clean for that time, why the additional 2.5 years?
Because as part of the plea agreement, it was articulated multiple times during arraignment at the plea and sentencing that the offer was 3.5 years incarceration, 5 years of post-release supervision, and all parties understood that that was the period of post-release supervision that defendant was going to receive. There was no question. It wasn't categorized as the minimum period of post-release supervision. On the other hand, it was the minimum period of incarceration.
So he waives it, and I don't know that there's any strong suggestion, at least not here today, that the appeal waiver was invalid. I know it was briefed, but that's not the sort of the thrust of what I heard from your friend during his argument. So what is, putting aside the waiver, what is the single strongest justification that, in your mind, warranting that 5-year PRS?
I see that my time is up, but I'm going to answer the question.
It's only up for you, not for us.
Beyond the fact that that was the bargain for agreement that he shouldn't be able to go back on at this point, although the people are sympathetic to defendant's motivation for causing the fire, he did pose a grave danger to his cousin who was in the apartment, his cousin's girlfriend. The entire apartment building actually had to be evacuated. There was significant smoke damage. So in attempting to take his own life, defendant put the lives of many other people at risk, and the recklessness of his actions shouldn't go ignored.
Okay, thank you.
Thank you. We ask that you affirm.
Okay, Mr. Clem, you get 1 minute.
2 very quick points. One, the record does reflect that Joshua was released on his conditional release date, indicating he didn't lose good time in custody and therefore had a good record in custody. Second, I did want to address waiver. I would not want this court to think that my silence on that point was anything other than my belief that the waiver is completely invalid. It's been found invalid by this court numerous times.
So the waiver, so your argument of is preserved in your brief, and I didn't mean to minimize or trivialize or ignore it, but
no,
cutting
but
to
I
the heart
did
of,
want to. I'm
sorry, go ahead.
I did want to address why it's invalid, which it's the classic issue that we see in these appeal waivers. The court never made clear that the right to appeal was not automatically forfeited as part of taking the plea. In fact, the court's language indicated just the opposite. And while no specific language is needed, not once did the court say anything like that it's a separate and distinct right from the Boykin right. So the waiver is completely invalid here, which permits the court to get to the...
you argue it's not cured by the written waiver.
Of course. Okay. Thank you.
All right. Thank you. Thank you both. Coombs?
Good afternoon, Your Honors. My name is Lisa Fitzgerald for the Defendant's Appellants. I just want to point out to the court that our appeal is limited to 2 distinct issues. We believe that the trial court was silent on 2 of these issues, and we'd like this court to reverse the ruling and dismiss plaintiff's 90 out of 180 claim, and also her claim for future lost wages, missed promotion opportunities, as well as flatlining of bonuses.
Can you address the lost wages claim first? Because that's the more interesting argument, at least to me.
I think it's more interesting as well. Thank you, Your Honor. Yes, the lost wages claim, it's speculative. I mean, there has been no evidence that that Ms. Coombs has lost any wages. In fact, her salary has increased.
But my understanding, it's not lost wages. It's really what she's talking about is a bonus, which granted is discretionary. Can't she show prior to the accident she got bonuses in X amount? People in her capacity, doing similar work, got X amount, but because of her injuries, she got less of a bonus or didn't get a bonus, whereas others continued getting bonuses. Why would that be speculative?
Well, Your Honor, she did, in fact, receive bonuses of $60,000 in the years 2013, 2014, and 2015, and then her bonus actually increased to $65,000 in 2016. I'm not aware right now what her bonuses have been in the past few years, but in terms of bonuses, they have not decreased at all. If anything, they have increased. And they are. They're not. She admitted in her testimony that the bonuses were not a mandated amount that she got, that they were discretionary. They were not only just based on her own job performance, but based on Disney's business performance.
But it is discretionary. Bonuses generally are, right? But generally, you're talking about employees that are able to travel, that are able to go the extra mile, which she claims she cannot, given her injuries, right?
Well, I think the record is clear that she was traveling immediately after the accident, and she still continues to travel. I think the record is clear that she's maintaining her job responsibilities as it was before the accident.
But we have a unique set of burdens for summary judgment in New York. So even as a defendant, non-counterclaiming defendant, and you're just defending the action, you're seeking summary judgment, you have to make an affirmative showing, right, through evidence in admissible form, that there are no triable issues of fact regarding the issue on which you're seeking summary judgment. So here it's the lost wages. It's not enough, I don't think, to stand on it's speculative. You've got to make at this juncture that affirmative showing that, as a matter of law, the plaintiff's lost wages claims are without merit, or that she cannot succeed on them. So where is the affirmative showing, on your initial burden on summary judgment, that as a matter of law, there are no triable issues of fact with respect to her lost wages claim?
In terms of a verifiable future lost wage claim, she testified herself that her salary, including bonuses, has actually increased. So right then and there, I can't speculate as to the future as to what may happen. She may.
What about the conversations with her prior boss about her bonuses? Where she talks about the boss's response was she should sit more.
Well, she did not provide testimony of the prior boss or anything of that nature for us to determine, but on this record, that she was, going to get a bigger bonus. I mean, her bonus, it's not as if her bonus decreased. I don't know per se what the business performance of Disney was, for example, in the year 2014 or 15. I mean, that's not. I don't believe that right here. That's a burden of the defendants to prove.
Well, she put testimony in with respect to her conversation to her prior boss. Is it her burden to show that, or is it your burden to demonstrate that there are no triable issues, as very eloquently stated by Justice Higgins?
Right. Yeah, and I believe
that's the problem with summary judgment motions. It's your burden to eliminate any issue. You have to prove it as a matter of law.
Right, and frivolous and speculative issues should not sustain summary judgment. And it's our position that a claim that her bonuses, number one, they stayed the same for a couple of years, but they did increase. I mean, that is relevant from her own testimony in the record. She didn't lose wages.
I just want to go back to Justice Higgins, because there's another issue as well, that since she was undergoing future treatment, I believe it was a neck surgery, she was prevented from even applying for a higher position, vice president, because of the treatment. And I don't think you refuted that at all.
Respectfully, I believe I do. The position was posted in June 2016. She didn't undergo surgery until August 2016, some 3 years after the incident. She wasn't prevented from applying for the position. She did not apply for the position. I mean, it seems commonsensical to me that if you don't apply for a position and you don't interview for the position, you can't now claim that you didn't get the position and you're out lost wages that she herself couldn't quantify. She said she'd be making it up as to how much of a pay increase this would be. She had no idea what the pay increase would be, if anything, if she even got the job. So respectfully, I don't think it's our duty right now, for example, to go to trial with the speculative lost earnings claim and missed promotion opportunities for a promotion.
Well, you have omnibus motions to make at that time, but let's talk about that at another point. Thank you, Counsel.
Okay, thank you.
Good afternoon, Your Honors. May it please the Court. I'm Dawn Panisi, counsel for plaintiff respondent in this matter. Since we've been talking about the lost wages component of the appeal.
Yeah, I mean, let's take 20 seconds on the 9180. I mean,
Sure.
Your own client testified that she came into work that following Friday, right?
Yes. Yes. I think the appellant's brief is ignoring the structure of her employment, and this kind of ties in with, you know, she's an executive at Disney. She said it. She's always working. She doesn't lose, you know, she didn't lose any wages per se because she's able to work from home. She can work from bed. But the defendant's brief is completely silent on some debilitating injuries that she suffered immediately following the accident within 90-180 days. And just to name one of the most egregious ones, her face struck the steering wheel when she was impacted, and she was barely able to open her mouth. She had significant difficulty talking, eating. I mean, if those aren't, you know, normal everyday activities that are curtailed to a great extent, I don't know what are. I mean, she got treatment right away, and the only thing that gave her relief were these this dual splint therapy, which it resembles hockey mouth guards.
Counsel?
Yes.
Did you state in the bill of particulars that she was only out for about 21 days, and didn't she testify to that in her depositions, that she was only out of work for 21 days?
Yes, she used, that's basically what happened is she had to use 21 of her sick days that she had, which is why she didn't lose any actual wages in that regard. And that 21 days.
But that goes to the issue of 90 out of 180 days.
Yes.
Correct?
Yes, Your Honor.
So we have your BP, your bill of particulars, and your client's sworn testimony to that effect.
Yes, yes, we do. And I did cite to some case law.
I'm listening to you, and I'm sure not being able to eat and all that is very difficult. But isn't there a basis in law that that's compensated, because a component of pain and suffering is loss of enjoyment of life? So isn't that really where those claims, if they are meritorious, would be entitled to compensation?
I think that would be for both claims, because these really were injuries that she was suffering from right after the accident. I mean, this was a workers' compensation case, so you know, these workers' compensation doctors, there was a specialist that treated her for the jaw injury. I mean, there's also the neck injury. She had a herniation at C6-7 that, I mean, her doctors told her she couldn't lift anything more than 15 pounds. Her workers' comp doctors told her she shouldn't be doing anything for the first 3 months because they didn't know exactly, you know, what was going on with the neck injury.
Yeah.
The MRI was taken within the first 3 months.
That's why you're running out of time on your
I'm
lost
sorry.
wages claim, so.
Yes.
Why don't you go to that?
So what I wanted to say was that Ms. Coombs had been an executive at Disney for 12 years, and that's when she became bonus eligible. Her bonus increased for 12 consecutive years until after the accident. And then her bonus stayed the same for 3 years, and then it only went up $5,000 that year later. And when she approached her boss, as she testified to, you know, one of the other things he said to her was that, well, your bonus didn't increase because your post-accident contributions to the company didn't increase. And with regard to the lost promotion, you know, the promotion for vice president of sourcing, she was director of sourcing. There's only a few of those in Disney. They're very scarce positions, and she had been groomed for this position. You know, she was unequivocal in her testimony that she was supposed to be the person in that position. She worked, you know, for 12 years to try to get this position. And unfortunately, the interviews were required in August of 2016, and that's when she ultimately ended up having her first cervical spine surgery. She actually asked, she testified that she asked, can we please just, can I take this position? Can I interview for it when I recover from my neck surgery? And the head person said that it couldn't wait. They had to fill that position. Thank you very much.
Thank you.
In terms of the 90 out of 180 claim, just a brief point on, it's the plaintiff's burden to submit objective proof of disability. So any reference to the defendant's experts not referencing the 90 out of 180 period in their reports is just, it's not applicable to this case. In terms of the future lost wage claim, future lost wage claims must be established with reasonable certainty. Jeffries versus 3520 Broadway, 36 AD 3D 421, this court, 2007. Summary judgment, it was appropriate to dismiss the future lost wage claim and missed promotion opportunities, as there can't be a trial where there's no certainty at all, not even reasonable certainty as to whether or not there are any future lost wages. And if there's no other questions, I rest on my brief.
Thank you.
Thank you.
People versus Garcia. Okay. Okay, so they waived that. Yeah, yeah. See, what happens is we allocate the time. Whoever reports, they need to get me that ahead of time so that I know who reported in. They're not showing up? Yeah. Gontarek?
Good afternoon, Your Honors. Harriet Wong on behalf of Defendants Appellants, New York City Transit Authority and Metropolitan Transportation Authority. I'd like to begin to draw Your Honor's attention to an admission in plaintiff's respondent's brief. There is no factual dispute that the plaintiff did not specifically allege he would require a future surgery in his bill of particulars. And here, defendants are insisting on the primacy of the bill of particulars based on the diverging evidence presented at trial. Plaintiff at trial presented...
Did Dr. Harrison, in his exchanged report, opine that plaintiff will need shoulder orthoplasty?
In the 3101D exchange on behalf of Dr. Harrison, the exchange, the notice itself does not mention anything about future surgery.
Attached, correct?
I'm sorry, Your Honor?
There's a narrative attached to the 3101D?
There is correct. There is a narrative report.
Did that put the defendant on notice that this claim was going to be made?
There is a report that actually says the opinion is that it's probable, that there's a probable
So it's
chance.
more likely than not, correct?
If the plaintiff's arthritis progresses. The specific report itself was exchanged in September of 2016, but immediately after, plaintiff's doctor had a treatment with the plaintiff. Plaintiff's actual treating orthopedist had a visit with the plaintiff in March of 2017, about 6 months after this expert report was exchanged, and that doctor specifically said, plaintiff will not need future surgery. The doctor said...
So that's really an issue for trial. So in this case, plaintiff's counsel opens saying he needs shoulder replacement. Plaintiff says he needs, there's no objection by defendant. Plaintiff testifies to it. Defense counsel takes their expert out of turn, who testifies that it's not needed, then a few days later, you make a motion in limine. How in the world have you not waived, if there is something wrong with that, how would you waive that objection?
I'm sorry.
How have you not waived an objection to that testimony, given the scenario I just laid out?
We did not waive the testimony at trial because we made a motion in limine to actually preclude any.
Ma'am, you made the motion 3 days after, you made the motion after the horse had left the barn, no?
I'm sorry, we made the motion.
It's okay, go ahead.
We made a motion in limine.
Idioms, you know.
Go on, I'm sorry, go on.
We made the motion in limine prior to plaintiff's expert actually testifying at trial.
But after counsel opens, no objection. After plaintiff testifies, no objection. After your witness says why no shoulder replacement is needed, then you made the motion.
Our doctor was actually prevented or precluded from actually testifying about the future surgery because plaintiff at the time of trial moved to preclude defense expert from providing any testimony about future surgery, even though the defense expert was taken out of turn and testified prior to plaintiff's counsel, and even though defendant's expert exchange had provided notice to plaintiff that defense expert will provide testimony about all evidence admitted at trial, including any permanency and any sequelae to plaintiff's injuries. Yet the trial court precluded defense expert from providing any testimony about the need for future surgery based on plaintiff's motion in limine. Then after defense expert was precluded, defendants at trial moved to preclude any testimony about future cost of surgery as to plaintiff's expert, and that was essentially denied because the plaintiff's expert was still permitted to testify about the need for future replacement surgery.
Well, that's because he was included in the 3101D report, right? He's allowed to testify about what he included in his expert report.
As to the probability of a surgery, at the time of trial, he didn't testify about the probability. He made it sound like it was definitively needed.
Okay.
And I will address this speculation issue on reply.
Thank you.
Thank you, Your Honors.
Good afternoon, Your Honors. Arnold D. Joseph for the plaintiff respondent, and it's great to be back. This has happened to me so many times, but this case is the poster child for failing to protect the record. Almost all the points in the appellant's brief, none of them, no exceptions were made, no cure. She's going to get up here and say that there was speculation because the jury heard about a potential future medical treatment, this surgery, but wasn't allowed to consider the cost, even though they sent a note 11 at the trial, specifically asking about this, and were told there were none to be considered, and then they still insist that this jury that took almost 2 days to deliberate, sent 12 notes, went over all this testimony, went off on their own, and somehow knew to incorporate the award into the future damages. The only speculation that's happening here is the defendant's speculation as to what the jury was doing. There's no proof in the record whatsoever, but there was no curative charge asked for. There was no exception made when this ruling was made. I don't, so.
And didn't all the testimony come in any of it? I mean, the
yes, and all this testimony came in. It came in without objection. Even the motion in limine, if you read the motion in limine, they don't ask to preclude the future surgery. They just ask to preclude the expense. And they don't make an exception when the judge makes a ruling at the end of it anyway.
So Dr. Manor, who's the defendant's expert, did he wind up testifying?
He was permitted to testify as to that the plaintiff did not need future surgery. He was allowed to do that because they allowed based on Harrison's report.
Right. So the jury has Dr. Manor and Dr. Harrison saying
correct.
Yes, no,
and that's
future surgery.
Correct. And even though Dr. Rosen, the doctor that did the surgery, didn't mention that the plaintiff needed surgery, that's still a question of fact for the jury. And it's clear that this jury probably accepted Dr. Harrison's opinion, which moves on to the next thing which I want to get to is the amount of the awards. The defendant spent a lot of time citing cases. Every one of the cases they cited supports awards between $200,000 for future pain, for past pain and suffering to $300,000. $200,000 to $300,000 for future pain and suffering. In this case, we have $300,000 and $300,000. And I think what was lost was the impact possibly that this gentleman's lifestyle had with the jury. This wasn't your normal guy who came into court. This was a super physically active gentleman who participated in multiple types of competitions. He scuba dove, he surfed, he did all this, and that is all out the window. And so it's the plaintiff's position here that look at the cases that are cited. Those awards from $200,000 to $300,000 for past and for future are all in the ballpark. So the jury's award here is in the ballpark, and if the court is going to tweak the award, it has the case law here to back it up.
Sir, understanding that under 5501C, we have to do sort of we have to look to prior precedents as guideposts, understanding that no two cases are the same. What is the strongest case or two that you want to point to?
I want to point to the Kearney.
Oh, go ahead.
I got one.
I
I cited it in my brief. It's this Kearney case from the 2nd Department where a construction worker fractured his shoulder, had surgery, and his awards were very high, and they were reduced to the awards that, pretty much to the awards that were made here. And the other thing is, if you look at the defendant's cases they cite, they're procedurally incorrect. They cite cases where the plaintiff didn't appeal the damages, and only the defendant did, and they were affirmed. Well, those are meaningless. They cite cases where the defendant won, and the plaintiff appealed, and it was only increased slightly. But the defendant has the benefit of the verdict there, and that has to be considered when you do these damages calculations. It is almost as if the defendant here thinks that you have some chart upstairs where you go, okay, guy broke his shoulder, this is what he gets. No, that's not what this court does. It's far more sophisticated. No, it just is. And the approach taken here, that you're just going to do 1 + 1 = 2, it's not correct.
Yeah. Well, not every plaintiff has run the Ironman competition.
No.
Has entered, right? So
that's true. Thank you, Judge.
Thank you.
Your Honors, if I may address the speculation issue, aside from the point that plaintiff was pointing at, the speculation of plaintiff's actual expert testimony is a major issue in our briefs because the plaintiff's expert testified to the need for future surgery when none of the medical records actually support that. Plaintiff's
Did you raise this at the trial level about that he should be precluded because it's speculative?
Unfortunately, Your Honor, we did not.
So how can we consider that?
Your Honors, in the interest of justice, we ask that this court not permit a verdict to stand that's based on speculation. The speculation of the need for future surgery is not only supported by evidence in the record based on plaintiff's medical records, physical therapy records, but also based on the fact that the bill of particulars fails to allege a need for future surgery that the plaintiff surprised us with in a 2016 report.
You also didn't move for a mistrial, right?
We did not move for a mistrial, Your Honors. But if I can borrow just one statement from plaintiff's brief.
Borrow it quickly. The time is up.
After all, in the race between justice and technicalities, justice should at least have an even chance. Thank you, Your Honors.
Thank you, Counsel. Very good. People versus Keller. People versus McClinton.
Good afternoon, Your Honors, and may it please the Court. My name is Kara Labini for Appellant Anthony McClinton. I'd like to address the court's denials of suppression and reopening in this case, which show why, as a matter of policy, appeal waivers should not foreclose appeals of cases implicating police misconduct. The prosecutor should not have the last word in those situations. That rule should apply here, where 5 to 7 police officers barged into an apartment lacking probable cause or an arrest warrant, arrested Mr. McClinton.
Can we back up? I don't think the facts are exactly like you're saying them. So how about just being a little more accurate on the facts? What occurred before? Was a gun found on the 4th floor? Did people run into an apartment? All that, isn't that something that would also be taken into consideration?
Sure, I'm sorry, Your Honor, I can hardly hear you.
I apologize, but that's our reality. What occurred prior to the events you're giving? Shouldn't that be taken into consideration, including the fact that a gun was found on the 4th floor, men ran into a particular apartment on the 4th floor? There are more facts than you're given, right?
Sure, yes, Your Honor, thank you. So the court below found that reasonable suspicion existed, but ripened into probable cause after entry was made into the apartment and a gun was found. There was no testimony at the hearing whatsoever that the gun was found prior to the arrest of Mr. McClinton. So whether or not there was reasonable suspicion to detain Mr. McClinton, to question him, to frisk him, there was certainly not probable cause. The guns that were found outside of the apartment or on the 4th floor were definitively linked to another person who never entered the apartment, and there was never any connection alleged between that person and my client. And when the testifying officer viewed that person dropping that gun on surveillance video during the freeze while officers were outside the apartment holding the men inside in there, their suspicion of my client dissipated, and their freeze should have ended right then and there because they knew that that gun had not been dropped by anyone who had ever entered the apartment. So there was no testimony showing that the gun was discovered prior to the arrest, so there was no way that the court could have properly found probable cause existed prior to the arrest. So the court should have suppressed the gun, should have granted re-argument, and then should have granted reopening once Sergeant King's grand jury testimony, who was actually there and who actually arrested Mr. McClinton, all but proved that the gun was found after Mr. McClinton was arrested.
Ma'am, if the appeal waiver was valid, then we don't get to this suppression issue.
So, Your Honor, the appeal waiver in this case was invalid because it suggested, the court's colloquy suggested that the waiver presented a final bar to Mr. McClinton's case. It said, you know, almost a direct quote, your conviction and sentence are final. And under People v. Bissono, a Court of Appeals case from 2019, that invalidates a waiver. Furthermore, you know, as I initially suggested, as a policy matter, appeal waivers should not cover suppression issues where there are issues of police misconduct. The prosecutor, there are unsavory incentives at play there, where the prosecutor can exact appeal waivers in the most egregious cases of police misconduct, where the legal reasoning below is the most seriously flawed, and for that reason, appeal waivers should not bar appeals.
Is there a case law that supports that proposition?
No, Your Honor.
So
you know, I'm sorry?
You want us to make that finding in this case?
Yes, Your Honor. We're asking this court to take another look at Seaberg, and should we lose here, we will plan to bring that issue to the Court of Appeals.
I mean, it's hard for us to take another look at Seaberg or Kemp because those are Court of Appeals cases. In this regard, these policy arguments would lead us to potentially do something in conflict with Seaberg and Kemp. So aren't those policy arguments better addressed to the Court of Appeals?
Well, Your Honor, I would say that if there was a case to do it in, this would be the case, as there is such egregious police misconduct that should be addressed. And your court is particularly well suited to examine the integrity of the process as the linchpin of constitutional and statutory design.
Thank you.
Thank you, Your Honors.
May it please the court, Shira Knight for the people. To begin, the record establishes that defendant validly waived his right to appeal. As such, this court does not need to address the merits of defendant's claims. However, if you do choose to do so, those claims are meritless. And just to address quickly with the waiver,
I mean, there was language in the court allocution that suggesting that the waiver may be an absolute bar to the taking of the appeal, right?
no, the judge was very clear, and he said that this waiver does not, you do not give up
He
the
used
right.
clarifying language after he made the suggestive language that the waiver may be an absolute bar.
No, one thing that he said is that it waives, it's a waiver to the extent provided under law, which implies that there are claims that survive. He also said you don't give up the right to take an appeal. And there's not to be a particular litany to encompass suppression rulings, as per the Court of Appeals in Kemp.
Well, the court doesn't have to engage in a particular, or use a particular litany, but here, was there a misstatement or a particularly potentially ambiguous statement in the beginning of the colloquy or toward the front of the colloquy?
No, I don't believe so.
Oh, you mean, so when the court says ordinarily, you will retain the right to appeal your conviction and sentence regardless of whether you were convicted after a jury trial or non-jury or plea guilty. But in this case, so you don't think that that first sentence is ambiguous as to whether defendant has retained his right to appeal?
No, I don't. And you also have to consider the fact that defendant's represented by counsel, and there's no presumption that counsel's ineffective at plea hearings. And also there's the written waiver, which helps to clarify it. So the court's colloquy, in addition to the written waiver and the advice of counsel.
Did the defendant have an opportunity to discuss the written waiver with counsel?
Yes, he did. And he also confirmed on the record that he understood. He actually affirmed that he understood that he could still appeal certain claims. So he understood the rights and the consequences that he was giving up and the consequences of the waiver. And just to move on to quickly, as far as the reasonable suspicion here and the officer's testimony, just to make it very clear, Detective Pinney stated, he asked him, at this time, referring to the time of the freeze, how many guns were recovered? And he answered 3. So it's in the record, it's in the hearing. He says there were 3 guns that were recovered before he froze the apartment.
Did he know that from his own firsthand knowledge, or was he told that by a fellow officer?
No, that's his knowledge. He observed the gun on the 2nd floor, on the 4th floor, and then there was also one from Howard that threw the gun over the ledge. And also, Howard went into the apartment. So this argument that it's somehow, defendants exculpated from any suspicion because Rush was the one who discarded the gun on the 4th floor, it's irrelevant. Howard went into the apartment with a weapon, and he exited the apartment by other means and went up to the roof. So these officers acted reasonably. This was a very dangerous, serious situation. These were guns that were discarded in a pursuit. Have a defendant who jumped into this pursuit voluntarily, it's very suspicious, and then ran into an apartment with the other people. He joined in, he wasn't the target of this pursuit, and yet he joined in.
Thank you, counsel.
Thank you.
So quickly, Your Honor, there was nothing in the trial testimony indicated that Detective Pinney had personal knowledge of the contents of the red bag, nor when it was searched, nor who dropped it, anything like that. Second, as to whether Howard ever entered the apartment, there was also nothing at the hearing that suggested how Detective Pinney could have closely pursued Mr. McClinton and the others when Howard went into an apartment.
Actually, isn't counsel correct? Wasn't defendant and a co-defendant in a lobby, and then they followed the cops up? Isn't that factually correct?
Essentially, yes.
But,
yes.
But how do you account for that? Generally, people run the opposite way when cops are in pursuit.
Oh, I'm sorry, Your Honor. So Group A, Howard and Rush, fled up the stairs. Group B, Vega and McClinton, then also fled up the stairs.
Oh, and then the cops came?
And then the cops pursued them. That's my understanding. I have a couple of things.
I thought that it was, that they followed the cops up.
No, I don't, no, Your Honor. I have one thing to say on the appeal waiver, if Your Honors will allow.
I'll give you 30 seconds.
Thank you. There were, as Your Honor suggested, the court made conflicting statements. You're waiving your right to appeal. Certain claims survive, but your conviction and sentence are final. How can the defendant understand the nature and consequences of the right waived, given those conflicting statements? And we submit that he cannot. Thank you, Your Honors.
Thank you. Thank you, counsel. I'm glad I gave time to argue in this case. Thank you both.
That was weird. I didn't expect to argue.
I know.
No, not yet.